This morning on the Ag Issues program. As always, a pleasure to be joined on the program by Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
Well, let's get to it. Got a lot of good topics to discuss, and one is the Farm Act, and the acronym for FARM is the Farm Assistance and Revenue Mitigation Act, and this was introduced by a member of the House Ag Committee, Mississippi Representative Trent Kelly.
Yeah, and just recently, in fact, just a few days ago, last week, indeed, and I think it has pretty good bipartisan support. If you look at the co-sponsors that he got lined up, he had a deadline of 9 a.m. last Friday, and sponsors came out of the woodwork for that. Unfortunately, I didn't see any Kansas co-sponsors on that, so that kind of disappoints me a bit, and I double-checked that. I don't think I missed anything. It may not pass as is, but I do think a version of it will pass, and it's designed to provide emergency assistance to producers of certain crops for the 2024 crop year. And I think the way this formula works, it could result in large payments to many farmers.
And this is as far as what crops are eligible. It looks like all crops are eligible potentially for these payments.
Yeah, they are, but the payments can get calculated in different ways. They list out 8 major crops, corn, soybeans, wheat, cotton, rice, sorghum, oats, and barley, to use one formula, and all other crops use a comparable estimate of gross return. So the formula is different. All crops are potentially eligible, but the formula for computing the payment is different depending on the type of crop.
And based on what we see on the current prices, of course, that is subject to change. What would it be for some of the major crops as far as the payments are payment per acre are concerned? Excuse me.
Yeah. Well, when we look at the formula, now keep in mind here what people need to note on this. A lot of farmers, of course, are familiar with ARC and PLC payments, and those are based solely on acres, base acres. The Farm Act bases payment on what you planted for 2024. So, for example, if we had a farmer that planted 1,000 acres of corn this year and 1,000 acres of soybeans, then the payment's going to be based on 1,000 acres of corn and 1,000 acres of soybeans. Plus, they would still be eligible for an additional 50% of the acres that were prevented from being planted. So you still have prevent plant payments in there, too. And the really nice thing, Greg, about this, when we get into how much per acre could be received by a farmer, I really like this, and there have been a group of us that have been telling people on the House Ag Committee and on the Senate Ag Committee that you really need to do this, and that is tell USDA what the formula is. Don't leave it up to the bureaucrats to mess around with these formulas. That has created problems for us in the past, and so what we have in this act is the specific formula that USDA shall use to compute these payments. And what it is for these 8 major crops is the USDA's projected cost of the crop less the national projected return. So you take that, and then you multiply all of that by eligible acres, then you multiply that by 60%, and that's your payment. And again, I think that is a very good feature of the bill to have Congress specifically tell the USDA how to calculate the payment. So to answer your question, based on current prices, where we're at today, the payment per acre would be about $103 for corn, $48 for soybeans, $82 an acre for wheat, $208 for cotton, $74 for rice, and then sorghum would come out to about $85 per acre, oats $181, and barley $3 per acre.
But with like ARC and PLC, there is a payment limitation with ARC and PLC. That's $125,000, if I'm not mistaken, and there would be a payment limitation for this?
Yeah, this one's higher. It's a per person per entity limitation, $175,000. So for individuals and entities that don't limit liability, the limit's on a per person basis. But if your farming operation is an entity that limits liability, then the limit is at the entity level, so you get one payment limit. So if I have 4 members, for example, of a general partnership, you could each of those members could be eligible for a payment of $175,000, which would be a total of $700,000. So if you're eligible for that much, that's the form of business that you want to be in. Before members of an LLC, for example, would have to split the $175,000 payment four ways, and that's $43,750 each. So that's a big difference from $700,000 down to $175,000. And I would point out, Greg, that can present a malpractice issue for attorneys that try to play around with farm estate planning, farm transition planning, and dabble in this. And let's say they're the big city law firm attorney, and you get this occasional farm client, and you put your standard estate plan in place that this looks good. You need to be an LLC or some other entity that limits liability, and you just cost them, in this instance, the difference between $700,000 and $175,000. You just cost them $525,000 of government payments in 1 year alone. You will get sued for malpractice. I have had over the years to unwind a couple of those for attorneys that just didn't know the rules after attending a seminar I did and hearing me speak and explain this. And you can see the malpractice dance, I call it, as I'm speaking. The sweat starts forming on their brow, and they start wiping that away, and they're paying careful attention to what I'm saying, and they haven't heard this before, and they've created these estate plans, and now they realize, that doesn't work with a farm client. And that's why what we do here with agricultural law is often law by the exception. You've got to be specifically trained in it.
Another topic of discussion, and this involves the plaintiff, which is a rancher on the Arizona-Mexico border. He claimed that the Biden administration violated the National Environmental Policy Act.
Yeah, and he won the case, too. This is a D.C. federal district court, and the judge there said, the National Environmental Policy Act is kind of a big deal, and what that means is that the government, anytime they undertake a major federal project, I'm defining it broadly here, they have to do what's known as an environmental impact statement. And his argument was, now, look, all of these trespassers coming illegally into the country are coming across my ranch. They've destroyed my fences. They've destroyed my land. They're leaving trash behind. My cattle eat trash. My cattle have died. They've stolen water out of my wells. And he said, the government should have done environmental impact statement on the policy of discontinuing that border wall and not enforcing Trump's Remain in Mexico policy before they decided to let all these people in violation of federal law. And the court said that's exactly right. The federal government has a duty under that National Environmental Policy Act to conduct an environmental analysis in order to stop existing federal, in order to stop the construction of the border wall, an existing federal project. And the court rejected the government's argument that stopping a construction project was not a major federal action. It didn't require a NEPA analysis, and also rejected the government's claim that getting a construction waiver under the Illegal Immigration Reform and Immigration Responsibility Act absolved them of their responsibilities under NEPA. And the court said, look, they only matter. Government, you violated environmental law when you discontinued that border wall and you discontinued Trump's Remain in Mexico policy. So you're in violation of federal law, and the only matter left for resolution is what's the appropriate remedy for the rancher? How do we make him whole? His ranch has been destroyed. And so he's entitled to damages, and we'll have to see what that is.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us, and always fun or not fun to talk about the Environmental Protection Agency, Roger. They just recently released a draft study, and that's designed to address the agency's, quote, failure, end quote, to meet its obligation under the Endangered Species Act on a pesticide-by-pesticide and species-by-species basis, and prepare for an increase in future herbicide registration reviews.
Yeah, and most of the time, Greg, it's not fun when we talk about EPA because they're imposing more regulations on the production of food and fiber in this country. And we've heard over the years, and you and I have talked about it past, these examples of environmental groups that sue the EPA to force a settlement out of them when they don't think there's been enough regulation. And that's what happened in this most recent instance, which has resulted in the EPA Office of Pesticide Programs proposing this draft strategy. Now, this is not in place yet, but it's coming unless we get a change in administration that takes out the leadership of, and forces a change in a lot of these bureaucracies at the leadership level. So keep that in mind too. But what they have done as a result of the supposed failure to meet their obligations under the Endangered Species Act is to identify species protections earlier in the pesticide review process, which there is that review process. They have to do that anyway under federal law, but they're identifying the species protections earlier in that process for endangered and threatened species and setting forth mitigation procedures that farmers will have to utilize. And so what they're looking at here are conventional ag herbicides in the U.S. on 264 million acres of farmland that were treated by those types of chemicals in 2022. And there's a lot of Kansas farmland that's in that 264 million acres. The draft strategy is the result of, again, here's this sue and settle process, an agreement that EPA entered into with the Center for Biological Diversity, and they're looking at mitigation practices on the control of herbicide runoff and erosion, as well as spray drift. So that's where the focus of this is going to be, and I think there's going to be significant impacts to farmers on that as a result of this.
Well, as an example, ground spray and spray drift, potentially every ground spray could require a 200-foot buffer, and aerial applications could require a 500-foot buffer. Mm-hmm. You're thinking 500 feet. That is almost 1.5, 1.75 sizes of football fields. So just picture that in your head. But that is something that is troubling, to say the least.
Yeah, if you're using chemicals, you better figure out what you're going to do, because I think this could result in significant acreage not being treated due to the possibility of downwind spray drift. And of course, the type of chemicals that you use, some are more volatile than others, and you and I have talked about the cases with respect to that also, and the volatility, the high volatility of some of these chemicals in the drift. And so spray drift mitigation is going to come into play here. And what they say in this draft strategy would be you need to put in windbreaks and hedgerows. You're going to have to use hooded sprayers, and you're going to have to reduce your application rate depending on the level of risk. And a lot of farmers are going to be impacted by this strategy, as I indicated. Now, they're trying to tie it to the Endangered Species Act, but more than 90% of species that are listed as endangered or threatened have at least some of their habitat on private land, and almost 70% of endangered or threatened species have over 60% of their total habitat on private land, on non-federal land. So this is something to watch. Now, this is going to get tied up in politics because this is not implemented yet. So if you get a change in administration, like I said, this could go by the wayside. But this is, again, one of these sue and settle type things. And so EPA has said, well, yeah, you're right. We'll settle this and we'll address our failures to meet our obligations under the Endangered Species Act by tightening these rules down on farmers.
Well, and it's as simple as, I think definitely people remember at the end of former President Obama's term going into President Trump's first term, what the changes were there. And obviously when President Biden won the election in 2020, and how that was just almost 100% reversed. And that's the exact same situation it sounds like we would follow there.
Yeah, exactly. And then you juxtapose that with this most recent federal court decision out of D.C., none other than in D.C., that said that the Biden administration was violating environmental law with their border policy. So it would seem like you kind of can't have it both ways. We're going to enforce environmental law here, put more restrictions on farmers, and we're going to ignore environmental law over here when it fits with our politics. That's what's tough for farmers. And of course, Greg, when we talk in a couple of weeks, maybe this will be a lot more clearer. I've got four tax seminars this week, and of course we're pre-election, and the questions I get is, what's the Harris plan? What's the Trump plan? Where are we at? What do we tell clients? And this week is a lot of, I don't know. Let's wait and see what happens. But I don't have a crystal ball that I can set on the middle of the table and just rub it and get a clear picture until we know who's going to control the White House, the House, and the Senate. What I have said is one thing is that I think there's only one scenario where the Tax Cuts and Jobs Act, or the Trump tax cuts, continue and don't sunset after next year, and that is if Trump wins and the Republicans get the House and the Senate. Then that's about the only scenario where the existing tax law would continue. Because if you have one piece of that fail, even if the Republicans win the House and the Senate and Harris wins, there's not going to be enough votes to override a veto or affirmatively change that policy. So you've got to have all three of those pieces, as I see it right now, in terms of tax policy. And that's another huge issue that's out there for farmers and ranchers right now.
Yeah, absolutely. All right, Roger, and like you said, you're very busy. Continue to be very busy. 2 weeks ago, you had events taking place, and you still have more events taking place as you head towards the end of the year here.
Yeah, I'm down to 31 remaining for the year. That takes me to December 20. And so, right now the voice is doing fine. I was in Texas last week, Idaho a few days before that. And this week is what I call Manhappiness Week. So I'll be in Manhattan. Here I leave in just a little bit to head over to teach all day, and then again on Wednesday, and then again on Thursday, and then also Kansas City on Thursday. And so still trying to figure out how I'm going to work Thursday to do two of them in the same day and a couple hours apart, but we'll figure it out.
Just drive really fast. All right. Roger, as always, if people want to follow you, anything you put up on the blog as well, what's the best way they can do that?
Well, the best way right now, because my website is dark because it's getting retooled, is go to Ag Manager at K-State, because I post the things there too. But you can still find me on Facebook and on Twitter and my Substack. That's all out there. It's just that the website's a little, it's waiting. I think it's about ready to be plugged into the law school, but we'll see here in the next few days.
All right. Roger, sounds good. As always, appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program right here on 580 WIBW.